So in other words, they could wait until January 30th and not pay you a penny, and you still cannot file an eviction against them until February 1st. Then on January 31st, they could walk in with 25% of the rent that they owe you, and you would not be able to evict them at that point.
So let's then move to the second time frame, if you will, the September to January 31st component.
That's the transition period.
Yeah, so the tenant doesn't pay during this period. How do we proceed?
So there's less protections for tenants on that one, but they sound very similar. In either time period, what we used to call a 3-day pay or quit has now transferred into a 15-day pay or quit. The caveat on that is that it does not include weekends or judicial holidays. So for example, this weekend's a holiday and the courts are closed on Monday. So if you were to serve that notice, let's say today, Saturday, let's say you served it 2 weeks ago and the 15 days has expired, but Monday's a holiday. Now it rolls over to Tuesday before the notice expires. So both periods are now 15-day notices to pay rent or quit. Both periods, the notices that are required in there have different sets of requirements. There are different statutory language that needs to be in those notices, different language for each period. There are unsigned declarations that have to be served with the notice. Candidly, what I would say to all of your clients is do not attempt to do this on your own right now. It is confusing for people like myself that do it every single day. I mean, we work through it and we have a good beat on it. But if you can see, if I'll hold this up, I don't know if you guys can see, I've probably read this law 10 times now and made different color highlights and notes all over the place. That's what it took me to figure out the correct procedures to do this. Don't attempt to do this on yourself. Either hire a law firm that is drafting the notices for you so they get the statutory language correct, or go to your trade organization, any of the apartment associations that you belong to. All of them are in the process of drafting their notices. In fact, I'm assisting a couple of them with drafting their notices right now. So don't try it yourself. Use the association or a law firm, and they will have the correct language. So you don't really need to do the brain damage of figuring out, okay, I'm in this period, which notice do I serve? Which language does it have? Which declaration do I serve? Just rely on the experts who do it.
Yeah, and to that point, so everyone understands, our viewers understand, there's 3 or 4 new documents that this law requires. One of them you mentioned is the 15-day notice that needs to have specific language in it. And unless you've already went out and sought the law online or what have you, you won't know what that language is. And then this declaration. So this tenant declaration, from what again, this needs to have specific language. So I concur with what Mike's stating here. You do not want to go this alone, because if you miss the language, you lose in court at the end of the day. With this tenant declaration, from what I gather, it's the tenants basically saying, I did have an issue with COVID, caused a financial hardship. I'm giving you my word, but they don't need to provide any other type of proof other than signing this declaration. Is that correct?
For the most part. There's another caveat to that. So yes, let's talk about them, and then we'll talk about the different notices that you can serve to what they call a high income tenant, because this law has a form of a means test in there. So the legislators did acknowledge that, you know, there are some people out there that make a pretty decent living, and even if they were impacted by COVID, maybe they shouldn't be afforded the same protections as, you know, the average blue collar working individual who doesn't make anywhere close to what they make. So let's unpack the average person first. Yes, they don't have to provide you with anything, basically, other than the signed declaration. They have to give that back to you within the 15-day period. Now, even if they give that back to you, you still can't evict them. What you have to do, once they sign that declaration and give it back to you, they have up until January 31st to pay you 25% of the rent that becomes due between now and January 31st. So in other words, they could wait until January 30th and not pay you a penny, and you still cannot file an eviction against them until February 1st. Then on January 31st, they could walk in with 25% of the rent that they owe you, and you would not be able to evict them at that point. So that's for the average person. So there are several components of this law that continuously give the tenant another bite at the apple. I'll give you an example. Even if the tenant doesn't return the declaration to you within the 15-day period, and you say, okay, then I'm going to file my eviction, and you file the eviction, the tenant can then go and file their declaration with the court within 5 days of being served the summons and complaint. And if they do that, so now, and you know the tenants' rights law firms are going to tell them, you don't even have to worry about that declaration. You can file that with the court later. Once they do that, the court is going to have a hearing on that filing, that declaration. And if the tenant can prove that through either mistake, inadvertence, excusable neglect, or surprise, that's why they didn't give it back to you within the 15 days, then the court will dismiss the unlawful detainer action. In other words, the tenant will have another bite at the apple. So the bill has done a fantastic job at protecting the tenants every step of the way. And I understand the rationale behind it. I don't agree with it. And I don't agree that essentially what ends up happening is the landlords are the ones carrying this debt for the next year to 18 months, possibly even a little bit longer. But that's, so like I said, they've built in all these backstops and these extra protections. So even if they don't do what they're supposed to, there's still one more step that they can rely on. And I have to be honest, it will depend on the judge and the court. For the judges in Los Angeles County, I hate to say this, but I anticipate any tenant who files that declaration with the court in LA County is probably going to have that ruled in their favor, just based on the way I know that the judges in LA County rule. And they're going to get, that case will be dismissed, and the tenant will get another opportunity to pay their rent. Now, let's talk about the high income tenants real quick, because they are still people that, you're going to be serving them notices. And a lot of people think, oh, well, if they're a high income tenant, then they're afforded less protections. And that is true, but only to a degree. They still have 15 days to pay. And here's the caveat with the high income tenant. You cannot, their notice has to have specific language in it that's different than the other tenants. And they also have to return their declaration. Now, with the high income tenant, the landlord is permitted to say, I need you to show me proof that you were affected by COVID. So let me define high income tenant for you. There's two categories, and then I'll show you how either way they can get out of it. They either have to be making 130% of the median income for that area, which, let's say, the median income will be determined by the number of people in the household. So if they're making 130% of the median income, then they're a high income tenant. Now, I can show you how, if I'm making 130% of the median income, I can still be not a high income tenant as soon as I give you the other definition. Anybody making more than $100,000 a year is also considered a high income tenant. But what if I'm making $101,000 a year, but I'm not at 130% of the median income? Then I'm not a high income tenant. Then I fall back into the regular tenant. Or what if I'm making 130% of the median income for that area, but I'm only making $99,000 a year? Well, then I'm not a high income tenant. So the way they did the definition of the high income tenant can definitely be played with, and the tenants' rights attorneys will certainly try everything they can to get that high income tenant knocked out of that category so that they do not have to provide the proof that they were actually negatively impacted by COVID. So also, one other very important rule on this high income tenant, if you serve an individual with a high-income tenant notice that has the specific language required for high-income tenants and notices, you have to actually have the information in your hands prior to serving the notice. So let me explain that a little bit. You would have to have known that they were a high-income tenant, for example, when they filled out their application. So I have a client that provided me with his tenant's application. I think I mentioned this the last time we were talking. The rent on the house is $10,000 a month. And when the tenant that's in there now filled out his application, as part of the landlord's due diligence, he asked for proof of income. That tenant provided trust documents that show that each month, he has a trust account that each month releases X amount of dollars. Okay, that's perfect. That's what you need, something along those lines, or pay stubs, or on the application they wrote, I make $150,000 a year. You have to have that information prior to serving the notice. You can't simply speculate and say, well, he's an attorney, or he's a doctor, or he's a CPA, or so they must be a high-income tenant. If you serve the high-income tenant notice without that proof in hand, the tenant can actually come back and contest it. And if you lose the case, then you're going to be on the hook for attorney's fees for that. So even when you're dealing with the high-income tenant, and everybody wants to shove the tenant into a high-income bracket because that allows them to ask for the proof that they were negatively impacted by COVID. But even with that, there's some landmines that have been built into this that you really need to be aware of before you do it. So again, don't try to go this on your own. Call the attorneys that know how to do this, and they'll walk you through the proper questions before they serve the notice.
Yeah, I think the bottom line on the high-income tenant, as I was reading the bill, is that, again, you had to have this documentation prior to the issue of non-payment of rent, and you cannot request it after the fact. And so That's come correct. October 1st, if they don't pay the rent on October 1st, you cannot now then go to that tenant who you know makes $200,000 a year and say, hey, I need that proof because I didn't collect it up front, but now I'm going to need it because we're going to court. Too late. You already needed the information.
That's absolutely true. Now, it doesn't mean that you can't allege that in court. Mm-hmm. You can allege he's a high-income tenant. He shouldn't be afforded these protections. And again, we're in uncharted territory. So I can't sit here and speculate how that will play out. I know that's certainly my game plan. If you tell me he's a high-income tenant, I'm going to get to court and I'm in discovery prior to getting to the trial. I'm going to request all those documents that prove that he's afforded protection in this situation.
So let's talk about this 75%. So we said that if a tenant doesn't pay between now and January 31st, they must pay 25% of the rent that's due, but that 25% technically is not due until January 31st. So they have until then to pay it. What happens to the remaining 75% that was due?